General Burwell, you'll have extra 10 minutes as well.
Thank you, Mr. Chief Justice, and may it please the Court. Standing has been raised, so let me start by telling you where we stand on standing, and then I'd appreciate the opportunity after that to summarize what I think are the two key points in this case. Now, with respect to standing, the question, the case or controversy question, turns on whether any of the four petitioners is liable for the tax penalty for 2014. Now, this case was litigated in the district court in 2013 based on projections on the part of each of the four petitioners that they would earn a certain income in 2014. They filed declarations saying that. With respect to two of the four, the projections of their income were such that they would qualify for the unaffordability exception and they wouldn't have standing. With respect to the other two, their projections were such that they wouldn't qualify for the unaffordability exception and they would have standing. But those were projections in 2013 about their income in 2014. 2014 has now come and gone, and we don't know, but petitioners know whether any of the four are in fact liable for the tax penalty, and that will depend on whether their actual income in 2014 matched their projections. Now, Mr. Carvin said there was fact-finding about this. I'm afraid that's not correct. The petitioners did file a motion for summary judgment, but the case was decided on the basis of the government's motion to dismiss before discovery and without any fact-finding. I'm assuming because Mr. Carvin has not said anything about the absence of a tax penalty that at least one of the four is in fact liable for a tax penalty, but that's the key standing question. Now, with respect to the veterans point, Your Honor, if it is the case, as Mr. Carvin tells us, that Mr. Hurst was a veteran for only 10 months, then I think he's correct. He would not qualify for VA health care because you generally have to serve 2 years. So that's where we are on standing. Now, if I could turn to the merits.
So are you saying one person does have standing?
No. It will depend on whether, as a factual matter, one of the four is in fact liable for the tax penalty for 2014. And that's information that is not in the government's possession. It is in the possession of Petitioner's Counsel. And I should make one more point with respect to 2015. There were no projections. There's nothing in the record about the possible income of any of the petitioners for 2015. So there's really nothing that would establish a case or controversy for 2014.
Well, you're surely not raising a standing question with us here for the first time at oral argument, are you?
Well, Mr. Chief Justice, as I said, that based on the projections, it was our understanding that at least one of the four would be liable for a tax penalty. The question of standing has been raised, and I've tried to identify for the Court what I think is the relevant question, which is whether any one of the four is in fact liable for a tax penalty, because
this is on a motion to dismiss, right?
Well, that's correct, Your Honor, but it does also go to this Court's jurisdiction, because if none of the four is liable for a tax penalty for 2014, there just isn't a case or controversy. None of them is liable. There's no injury. And so I do think that's ultimately the relevant question here with respect to standing. I don't think there's a question about veteran status, but I do think that's the relevant question.
Well, isn't the question before us as to standing whether the district court correctly held in the motion to dismiss context that there was standing? That may not be the end of the matter, but don't we have to — isn't that what is before us?
Well, that may be correct. Yes, but then you might alternatively think about this as a question of mootness, I guess, and that, based on the projection, there was a case or controversy, but if the projection didn't come to pass and none of the plaintiffs is liable for a tax penalty, then the case or controversy no longer exists.
Well, what are you suggesting? Should we have a trial here?
No, I'm not
on this issue and find what the facts are?
Justice Alito, I did not raise standing affirmatively. The Court raised it, and I'm just doing my best to let the Court know what our position is on standing.
Well, would you send it back then to the district court?
Well, I guess what I've said is that Mr. Carvin hasn't suggested that there's no plaintiff liable for a tax penalty. Based on that, I'm inferring that at least one of the petitioners has standing.
Why wouldn't we accept a representation by him?
There's no reason not to.
If he makes a representation that at least one of the four was liable in 2014 and is liable in or will be liable in 2015.
So I guess
we know at least one of them won't, because that's
what I'm saying about that is I'm actually going a step further than that, Justice Sotomayor. Given that there hasn't been — I'm willing to accept the absence of a representation as an indication that there is a case or controversy here. And so that's why Mr. Chief Justice, we haven't raised standing, and that's what. But I do think that the key question is whether one of the four is liable for a tax penalty. You have to have that to have a case or controversy case. If I could now, let me please turn to the merits and summarize what I think are the two key points. First, our reading follows directly from the text of the Act's applicable provisions, and it's really the only way to make sense of both Section 36B and the rest of the Act. Textually, their reading produces an incoherent statute that doesn't work. And second, our reading is compelled by the Act's structure and design. Their reading forces HHS to establish rump exchanges that are doomed to fail. It makes a mockery of the statute's express textual promise of state flexibility. It precipitates the insurance market death spirals that the statutory findings specifically say the statute was designed to avoid. And, of course, it revokes the promise of affordable care for millions of Americans. That cannot be the statute that Congress intended.
Of course it could be. I mean, it may not be the statute they intended. The question is whether it's the statute that they wrote. I mean, you know, there are no provisions in a statute that turn out to be ill-considered and ill-conceived.
So it's not the statute that they wrote. And the reason it's not the statute that they wrote, I think I want to actually start, if I could, picking up, I think, on a variation of the hypothetical that Justice Kagan asked. In Petitioner's brief, they throw down the gauntlet with respect to a hypothetical about airports. And that a statute that requires a state to construct an airport says the federal government shall construct such airport if the state doesn't, and no one would think that the federal government's airport was an airport constructed by the state. Well, what I would say to that is that if those statutory provisions were conjoined with a provision that said airplanes may only land at airports constructed by the state, that you would conclude immediately that that a federally constructed airport qualifies as an airport constructed by the state, and because otherwise the statute would make no sense, and the same exact thing is true
here. There are no statutes that make no sense.
This one
makes
sense.
Is that the case? Every statute must make sense, and we will twist the words as necessary to make it make that can't be the rule.
That isn't the rule. But the rule is that you don't read statutory provisions in isolation. You read them in context. The rule is that you read them in order to ensure that the statute operates as a harmonious whole. You read them so that you don't render statutory provisions ineffective. You read them to promote
where that is possible.
Balance.
I mean, you acknowledge that all of what you're saying only applies where there are alternative readings that are reasonable. You pick the one that will do all the things that you say. But if it can only reasonably mean one thing, it will continue to mean that one thing, even if it has untoward consequences for the rest of the statute. No?
With respect to this statute, first, I want to make 2 points. First,
but answer me in principle. I mean, is it not the case that if the only reasonable interpretation of a particular provision produces disastrous consequences in the rest of the statute, it nonetheless means what it says? Is that true or not?
I think there are a couple of limitations on that principle. The first is, if what you have is a situation in which that it creates conflict within a statutory scheme, then the Court's got to do its best to try to harmonize and reconcile the provisions. And
well, I disagree with that. You have a single case in which we have said the provision is not ambiguous, it means this thing, but, Lord, that'd make a terrible statute. So we will interpret it to mean something else. Do you have
sure,
one case where we've ever said
Brown and Williamson's a good example of that. In Brown and Williamson, the Court said, look, the definition of drug and drug delivery device would actually seem unambiguously to cover tobacco, but when you read that provision in context and considering the full scope of the regulatory regime, it can't possibly mean that. But let me actually work through the text here, because I do think I can show you that there's a quite reasonable reading of this statutory text that allows you to affirm and requires you to affirm the government's position.
General Verrilli, before we get too immersed in a number of provisions of this, could you respond to a question that was asked during Mr. Carvin's argument? If we adopt Petitioner's interpretation of this Act, is it unconstitutionally coercive?
So here's what I would say about that, Justice Alito. I think that it would certainly be a novel constitutional question, and I think that I'm not prepared to say to the Court today that it is unconstitutional. It would be my duty to defend the statute and on the authority of New York versus United States, I think we would do so. But I don't think there's any doubt that it's a novel question. And if the Court believes it's a serious question,
I was going to say, does novel mean difficult? Because it does seem to me that if the petitioner's argument is correct, this is just not a rational choice for the states to make, and that they're being coerced. And that you then have to invoke the standard of constitutional avoidance.
Well, what I was going to say, Justice Kennedy, is to the extent the Court believes that this is a serious constitutional question and this does rise to the level of something approaching coercion, then I do think the doctrine of constitutional avoidance becomes another very powerful reason to read the statutory text our way. Because I do think with respect to the point that Your Honor is making, remember, it's not just a situation in which there's onerous conditions, onerous consequences for state residents. It's also a profound problem of notice here. That, if you take petitioners' reading of the statute, then the idea that states were given you can't possibly justify this as adequate notice to the states.
Well, Mr. General Burwell, let me ask you this about notice. We get lots and lots of amicus briefs from states. And we got 2 amicus briefs from states here. 34 states, I think that's the number, the states that declined to or failed to establish a state exchange.
Correct.
Now, if they were all caught off guard and they were upset about this, you would expect them to file an amicus brief telling us that. But actually, of the 34, only 6 of them signed the brief that was submitted by a number of states making that argument. 23 states, 23 jurisdictions submitted that brief. 17 of them are states that established state exchanges. Only 6 of the states that didn't establish state exchanges signed that brief. How do you account for that?
So I guess I'd make 2 points about that, Justice Alito. First, you've got 22 states there, states in both camps, all of whom told you that they didn't understand the statute that way. And with respect to the other 8 states that filed the amicus brief on the other side, I actually think there's quite an important point that goes to their understanding of what this Act did. Remember, this is an IRS rule that we're talking about here, and the IRS put out a notice of proposed rulemaking saying this is what we intend to do. And several of these states, Oklahoma, Indiana, Nebraska, they filed rulemaking comments in that proceeding. And if you look at those rulemaking comments, you will see that they address a number of issues, and they say nothing about the issue that's before the Court now. So if they really understood the statute as denying subsidies in states that did not set up their own exchanges, that would have been front and center in their rulemaking comments, but they said nothing about it. And I think that tells you a good deal about what everybody understood that this statute was.
Well, there's another point on notice on this Penthurst argument that seems curious to me. Usually when this argument comes up, a state has signed up for a federal program and then they say, oh my gosh, we didn't realize what we had gotten ourselves into. But here, it's not too late for a state to establish an exchange if we were to adopt petitioner's interpretation of the statute. So going forward, there would be no harm.
Well, let me address that directly, and then I'd like to make a broader point about statutory context and response. Now, directly, of course, I don't think it's possible to say there would be no harm. The tax credits will be cut off immediately, and you will have very significant, very adverse effects immediately for millions of people in many states in their insurance markets.
I said going forward, and then after the current tax year.
And then
and would it not be possible, if we were to adopt petitioner's interpretation of the statute, to stay the mandate until the end of this tax year, as we have done in other cases where we have adopted an interpretation of the Constitution or a statute that would have very disruptive consequences, such as the Northern Pipeline case?
Sure. Northern Pipeline is an example of doing that, and of course, it will be up to the Court to decide whether it has the authority to do that. I will say this does seem different than Northern Pipeline to me, because this is about money going out of the federal treasury, which is a different scenario. But if the Court, obviously, if that's where the Court's going and that's what the Court thinks the proper disposition is, that would reduce the disruption. But I think it's another important point to make here, just as a practical matter. The idea that a number of states, all these states, or a significant number, are going to be able in the 6 months between when a decision in this case would come out and when the new year for insurance purposes will begin, will be able to set up exchanges, get them up and running, and get all the approvals done, I think is completely unrealistic.
How long has it taken?
Just to give you an example of the current timeline, Justice Ginsburg, in order to have an exchange approved and insurance policies on the exchange ready for the 2016 year, those approvals have to occur by May of 2015. Okay, so that gives you a sense of the timeline that HHS is operating under. Now,
what about Congress? You really think Congress is just going to sit there while all of these disastrous consequences ensue? I mean, how often have we come out with a decision, such as the bankruptcy court decision? Congress adjusts, enacts a statute that takes care of the problem. Happens all the time. Why is that not going to happen here?
Well, this Congress, Your Honor, of course, theoretically, they.
I don't care what Congress you're talking about. If the consequences are as disastrous as you say, so many million people without insurance and whatnot, yes, I think this Congress would act.
But the relevant question, and then I'm going to try to get back to the point I was trying to make in response to Justice Alito's question. The relevant question here is, what did the Congress that enacted this statute in 2010 do? Did they really set up a system in which the states are subject to the kind of onerous situation that the petitioner claims? And I think there are three textual indications, objective textual indications, that cannot possibly have been the statutory scheme that Congress tried to set up. First is the existence of the federal exchanges. It would make no sense for Congress to have provided for federal exchanges if, as Mr. Carbon suggests, the statutory design was supposed to result in every state establishing its exchange. Second,
well, wouldn't it have been, again, talking about federalism, a mechanism for states to show that they had concerns about the wisdom and the workability of the Act in the form that it was passed?
So, Justice Kennedy, I think the federalism values are promoted by our interpretation, because if that is indeed what a state thought, if a state really would have preferred not to have the state government participate in the implementation of this Act for reasons that Your Honor identified, the structure of the Act that Congress put in place and that we're advocating for today fully vindicates that concern. They can decide not to participate without having any adverse consequences visited upon the citizens of the state. And that's why our reading is the pro-federalism reading. It's their reading, that seems to me, that is the anti-federalism reading, and that's a powerful reason to reject it. And if I could go to the second statutory point, which is related to what we're talking about, Justice Kennedy, which is Section 1321 says that this statute is designed to afford state flexibility. State flexibility. It would be an Orwellian sense of the word flexibility to use it in the manner that petitioners say the statute uses it, because it's the polar opposite of flexibility. And the third point, seems to me, is the notice point, that if indeed the plan was, as Mr. Carvin said, that every state was going to establish an exchange for itself, and that would cure all of the massive statutory anomalies and textual anomalies and absurdities and impossibilities that his reading provides for. If that was really the plan, then the consequence for the states would be in neon lights in this statute. You would want to make absolutely sure that every state got the message. But instead what you have is a subclause in Section 36B, which is a provision that addresses the eligibility of individual taxpayers for tax credits.
This is not the most elegantly drafted statute. It was pushed through on expedited procedures and didn't have the kind of consideration by a conference committee, for example, that statutes usually do. What would be so surprising if among its other imperfections, there's the imperfection that what the states have to do is not obvious enough? That doesn't strike me as inconceivable.
So, Justice Scalia, I'm going to answer that question by talking about the legislative process, because I think it is quite relevant, and I think it ought to be quite relevant even to you with respect to the question you just asked. The language here in 36B was not the product of some last-minute deal. It wasn't the product of scrambling at the end. The language that emerged here, the statutory structure with the language of 36B about tax credits, the language that's in 1311, and the language that's in 1321, was the product of the Senate Finance Committee markup, which went on for weeks and weeks. It was a public hearing. It was covered by C-SPAN. You can go watch it on the C-SPAN archives if you want to, and you will see coming out of that the understanding, the clear understanding was what this statutory setup would result in subsidies being available in every state.
There were senators, were there not, who were opposed to having the federal government run the whole thing because they thought that would lead to a single-payer system, which some people wanted. And the explanation for this provision is it prevents the federalization of the entire thing.
No, Justice
Scalia, it's certainly a plausible explanation of why the provision's there.
Mr. Carbon has floated that as an explanation, and he suggested it was Senator Ben Nelson who required it. There's absolutely no contemporaneous evidence, none whatsoever, that anybody thought that way, that the solution to the problem that Your Honor's identified is what Congress did by having states have the option to set up their own exchanges with state-by-state federal fallbacks rather than national system. Senator Nelson has made clear, he has stated, that he had no intention of the kind. There's no contemporaneous evidence at all that anyone did. And what Mr. Carbon has suggested is that this was the product of some deal to try to get votes so the act could get passed. What I would suggest to Your Honor is that there is objective proof that that is not true. The provisions in the Act that were negotiated at the end to secure the necessary votes are in Title 10 of the Act. And if you look in the Act, pages 833 to 924, that's Title 10, you can see all of the amendments. Not a single one has anything to do with the statutory language before the Court.
Well, the puzzle that's created by your interpretation is this. If Congress did not want the phrase established by the state to mean what that would normally be taken to mean, why did they use that language? Why didn't they use other formulations that appear elsewhere in the Act? Why didn't they say established under the Act? Why didn't they say established within the state? Why didn't they include a provision saying that an exchange established by HHS is a state exchange when they have a provision in there that does exactly that for the District of Columbia and for the territories? It says that they are deemed to be states for purposes of this Act. So why would they do that?
So, of course, the provision doesn't say established by the state with a period after state. It says established by the state under Section 1311. And our position textually is, and we think this is clearly the better reading of the text, that by cross-referencing Section 1311, effectively what Congress is doing is saying that exchanges established through whatever mechanism, exchanges set up by states themselves.
So you're saying that by cross-reference to 1311, they really mean 1311 and 1321?
Yes, well, I do think that, and let me walk through why I think that's true.
That seems to me to go in the wrong direction in your case, not in the right direction.
No, I think it goes in the right direction if you just ride with me for a little bit, Justice Kennedy.
Before you get on to that, your answer doesn't explain why by the state is in there. Then why didn't they say established under 1311?
Well, so the second point is that wherever this provision appears in the Act established by the state under Section 1311, it's doing work. And the work it's doing is saying what we're talking about is the specific exchange established in the specific state as opposed to general rules for exchanges. If you look at the Medicaid maintenance of effort provision, the CHIP, it works the same way.
Well, why didn't they say in the state? That's the phrase you just used, in the state. Why didn't they say in the state?
Because I suppose they could have, but it worked perfectly well this way. If you look at the qualified individual provision, it's clearly how they're using it with respect to the qualified individual provision. With respect to that provision, it says a qualified individual is a person who is located, who resides in the state that established the exchange. Clearly what they're talking about is a geographical reference to the particular state. That's what's going on there. It's what's going on every time the statute uses that phrase. So it's doing that work, and that's why it's in there. But now if I could go back to your point, Justice Kennedy, it says established by the state under Section 1311. Section 1311b1 says each state shall establish an American health benefits exchange for the state. It's not, as Mr. Carvin said, an urging that states do it. It says each state shall establish. Now, we know that when Congress used that language, each state shall establish, it must have meant something more inclusive than each state government shall itself set up the exchange. We know that because Congress is legislating against the backdrop of the 10th Amendment, and so it couldn't impose that requirement. And we know that because of Section 1321, because Section 1321 provides the means by which the 1311b1 requirement is satisfied. It can be satisfied by a state electing to meet the federal requirements for exchanges, or it can be satisfied in the event that a state doesn't or tries but comes up short by HHS stepping in and establishing the exchange.
So when the statute says each state shall establish, it really means the federal government shall establish if the state doesn't establish.
I think the right way to —
and if that were the correct interpretation, you wouldn't need 1321 at all.
So, no, I think the right way to think about this, Justice Alito, is that what's going on here is that the right place to focus — let me put it that way — the right place to focus here is not on the who, but on the what, on the thing that gets set up and whether it qualifies as an exchange established by the state. And these exchanges do qualify, and the reason they qualify is because they fulfill the requirement in Section 1311b1 that each state shall establish an exchange. And 1321 tells you that because it says to the HHS that when a state hasn't elected to meet the federal requirements, HHS steps in, and what HHS does is set up the required exchange. It says such exchange, which is referring to immediately prior to the required exchange, where the only exchange required in the Act is an exchange under Section 1311b1. So it has to be that what HHS is doing under the plain text of the statute is fulfilling the requirement of Section 1311b1 that each state establish an exchange. And for that reason, we say it qualifies as an exchange established by the state. That's reinforced, as Justice Breyer suggested earlier, by the definition, which says that an exchange is an exchange established under Section 1311. 1311, again, as 1311b1, which says each state shall establish an exchange. And it has to be that way because petitioners have conceded, and it's at page 22 of their brief, that an exchange that HHS sets up is supposed to be the same exchange, and then petitioners say function just like an exchange that the state sets up for itself.
You're putting a lot of weight on the one word such exchange. It seems to me the most unrealistic interpretation of such to mean the federal government shall establish a state exchange. Rather, it seems to me such means an exchange for the state rather than an exchange of the state. How can the federal government establish a state exchange? That is gobbledygook.
So,
such must mean something different.
It isn't gobbledygook, Justice Scalia, and I think about it, and go back to something that Justice Alito asked earlier, in that, look, if the language of 36B were exactly the same as it is now, and the statute said in 1321 that an exchange set up by HHS shall qualify as an exchange established by the state for purposes of Section 1311, you wouldn't change the language of 36B one iota, and there wouldn't be any doubt in anyone's mind that that subsidies were available on federal exchanges. And what we're saying is that effectively reading 1311 and 1321 together, that is what the statute does. And that certainly that is a reasonable reading of the statute. It is really the only reading of the statute that allows you to be faithful to the text of 1311b1, the word shall, and to the 10th Amendment. In order for
the word such means not just the exchange that the state was supposed to set up, but it means the state exchange.
It means an exchange that qualifies as an exchange established by the state because it satisfies the requirement of 1311b1.
You have to say it means the state exchange. You have to. Your case hinges on the fact that a federal exchange is a state exchange.
It hinges on it qualifying as the state exchange or being equivalent to the state exchange for purposes of the operation of the statute. That is a reasonable reading of the particular textual provisions. And once you've concluded that it's a reasonable reading of the particular textual provisions, then you have to read it the way that we say it is to be read, because it is the only way to make sense of the statute as a whole. It is the only way to bring it into harmony with the Act's qualified individual and qualified health plan provisions, which do lead to what they admit is an absurdity under their reading of the law.
Would you agree that there are provisions of the Act where the exact same phrase, established by the state, has to be read to mean established by the state and not by HHS? There are some provisions like that.
They've pointed out some, but I think they're wrong about each one. I don't know.
All right, well, let's take one. I'd be interested in your answer to it. 42 U.S.C. Section 1396W-3H1D, which says that each state shall establish procedures to ensure that an exchange established by the state utilizes a secure electronic interface. And they say that if exchange established by the state there is read to mean an HHS exchange, that means that the state in which that exchange is established is responsible for making sure that the federal exchange has a secure electronic interface.
Yeah, they're just wrong about that. It's just completely wrong. The statute says that the state shall — first of all, the statutory obligation is addressed to the state Medicaid and CHIP agencies. And what it says is they shall establish procedures to ensure the coordination. HHS has issued regulations setting forth what that statutory provision requires of states in those circumstances. Every state where there's a federally facilitated exchange has met the requirements and fulfilled them, and it works perfectly fine. There's no anomaly there at all.
The state
it met the requirements of the regulation, you say. But do the regulations track the statute?
Yes, they do.
Do they give the state authority to say whether or not these conditions have been met?
The requirements are imposed on the state Medicaid and CHIP end of the relationship. That's what the statute does. And the regulations implement that statutory requirement, and it's satisfied in every state. And, of course, as Your Honor, reading it to me, said, it does say, and I do think that proves our point, the statute says each state shall. It doesn't say states that have set up exchanges for themselves shall. It says each state shall. It presupposes that there's going to be something that qualifies as an exchange established by the state in every state. So there's no anomaly there. And if Your Honor wants to ask me about any of the other ones, you can, but there are no anomalies, frankly.
I think, as I understand your answer to be, that there are federal regulations telling the states what they have to do here, and they've all done it. But the fact remains that the state has some obligation under the regulations to make sure that there's a proper interface with the federal exchange.
On the state side of the interface, yes. But that's the CHIP and Medicaid agencies. Those are state government agencies, and it's their side of the interface that the statute governs. And, as I said, I don't think there are anomalies with our reading, but if they are, they pale in comparison to the anomalies on the other side. I mean, I really do want to focus on this point about the qualified health plan and the qualified individual, because the statute is quite clear in Section 1311 that an exchange, not an exchange established by the state, but an exchange, can only sell a qualified health plan. It is forbidden from selling a health plan that is not a qualified health plan. And that's not an exchange established by the state, it's an exchange. Now, the statute also says that to certify a health plan as qualified, the exchange has to decide that it is in the interest of qualified individuals. Now, qualified individuals are persons who reside in the state that established the exchange. So if you read the statute, the language, the way Mr. Carbon reads it, instead of the way we read it, you come to the conclusion, and in a state with a federally facilitated exchange, there are no qualified individuals. Therefore, the exchange cannot certify a qualified health plan as being in the interest of qualified individuals because there aren't any. So there aren't any qualified health plans that can lawfully be sold on the exchange.
What is the provision that says that only a qualified individual can enroll in a plan under an exchange?
So I will address that, but I just want to make clear the provision I'm talking about with respect to the prohibition on selling a qualified health plan to anybody on anything other than a qualified health plan on an exchange is 1311 D2B, which is at page 8A of the appendix to our brief. It's absolutely unambiguous. An exchange, not an exchange established by the state, an exchange may not make available any health plan that is not a qualified health plan. So
a qualified health plan. But what's the provision you were referring to when you said that an exchange may enroll only a qualified individual?
Well, what the statute says throughout is that qualified individuals are eligible to purchase on exchanges. And it's the necessary meaning of that phrase that if you are not a qualified individual, then you are not eligible to purchase health care on an exchange, because otherwise the word qualified would not have any meaning. The meaning of the word qualified is to distinguish between people who are eligible and people who are ineligible. And as a policy matter, it wouldn't make any sense, because think of the people who are not qualified individuals. They're people who don't live in the state, they're people in prison, and they're unlawfully documented aliens.
Part of Section 1312. A person qualified to purchase on an exchange must, quote, reside in the state that established the exchange.
Right. And there are no such people in 34 states under Mr. Carvin's theory of the statute. So it just doesn't you just run into a textual brick wall.
Well, I understand your argument is that it's a logical inference from a number of provisions that only a qualified individual may purchase a policy. But I gather there is no provision that you can point to that says that directly.
Well, that's what qualified means, Justice Alito. It means that, if you're not qualified, you're unqualified. And so, that's what it means. And so you're just reading the word qualified out of the statute if you read it that way. And
qualified is used in the lay sense of the term. It's not a technical term here.
Well, I think, given the way it's defined as a person who resides in the state. It excludes people out of state. It does that because the statute was quite clear that you weren't going to be allowed to shop for insurance policies across state lines, because that would infringe on traditional state prerogatives regulating insurance. And with respect to prisoners, it doesn't make any sense to say that prisoners should be able to get insurance. Mr. Carvin says, yes, it does, because they get out of prison. Well, there's a specific statutory provision that says when you face a changed life circumstance, such as getting out of prison, you can sign up for insurance at that point. He makes the point about unlawfully present persons being both unqualified and not being able to be covered, but that's not surplus. That's there for a very important reason, which is that somebody can be in lawful status and therefore be eligible for health care, but then lose lawful status, and at that point they can no longer be covered. So just none of that works for them. None of that works for them. But to get to the fundamental point here, that both at the level of text, you have clear, irresolvable conflicts, so that the statute can't work if you read it Mr. Carvin's way. You have, at the level of text.
Is that a synonym for ambiguity?
I think so. Exactly right, Justice Scalia. Justice Kennedy. that you have ambiguity there precisely because you have to, this is a statute that's going to operate one way or the other. And the question is how it's going to operate. And when you read it their way, you run into a complete...
If it's ambiguous, then we think about Chevron, but it seems to me a drastic step for us to say that the Department of Internal Revenue and its director can make this call one way or the other when there are, billions of dollars of subsidies involved per year, hundreds of millions?
Yes, there's billions of dollars of subsidies involved per year. But 2 points about that.
And it seems to me our cases say that if the Internal Revenue Service is going to allow deductions, usually it has to be very, very clear.
So,
and it seems to me a little odd that the Director of Internal Revenue didn't identify this problem if it's ambiguous and advise Congress at once.
So a few points about that with respect to Chevron deference. First, we do think Chevron deference clearly supports the government here, and I'll explain why. But before you get to that, you can resolve and should resolve this statute and the statute's meaning in our favor even without resort to Chevron deference. That's what the canon of reading a statute as a whole to make it work harmoniously directs you to do. It's what the very important principles of federalism that we've been describing here direct you to do. If you think there's a constitutional problem with the statute, it's what the doctrine of constitutional avoidance directs you to do. Now, with respect to Chevron, Section 36BG of the statute expressly delegates to the IRS the specific authority to make any decisions necessary to implement Section 36B. So you don't have any ambiguity. Congress said the IRS should do this. It is a big question But as the Court said in City of Arlington 2 terms ago, Chevron applies to big questions as well as small. Your Honor raised this point about the need for clarity in tax deduction and IRS in the statutory reading of tax deductions. There is a learned treatise that describes that as a false notion, and it's certainly not consistent with this Court's unanimous decision in Mayo 2 terms ago that Chevron applies to the tax code like anything else.
If you're right about Chevron, that would indicate that a subsequent administration could change that interpretation?
I think a subsequent administration would need a very strong case under Step 2 of the Chevron analysis that was a reasonable judgment in view of the disruptive consequences. As I said, I think you can resolve and should resolve this case because the statute really has to be read when taken as a whole to adopt the government's position.
General,
but I do take
if there are any tax attorneys in the courtroom today, I think probably they wrote down what you just said. When we get future tax cases, the United States is going to argue that we should not read them to there should be no presumption that a tax credit is provided by that statute.
You should read it according to its terms. And when you read this provision according to its terms and you read it in context and you read it against the background principles of federalism, you have to affirm the government's interpretation. Thank you.
Thank you, General.